Hi, and thanks for joining us for today's webinar from the Institute for Research on Poverty at the University of Wisconsin-Madison. I'm Judith Sears-Poisson, and I'm happy to be your host. Our webinar today is on policy and practice approaches to supporting low-income renters at risk of eviction. And we're fortunate to have three great researchers with us today. First, we'll hear from Dr. Mike Lentz, who is an associate professor of urban planning and public policy at the UCLA Luskin School of Public Affairs. He'll set the stage of the eviction system that low-income renters face, drawing especially on his work on centering the institutional life of eviction. Sorry, a little cough there. Next, we'll turn to Dr. Eva Rosen, who's the Provost's Distinguished Associate Professor in the McCourt School of Public Policy at Georgetown University. She'll share her research on the experiences of low-income renters in housing court, as outlined in her paper, Navigating an Overburdened Courtroom: How Inconsistent Rules, Shadow Procedures, and Social Capital Disadvantage Tenants in Eviction Court. And then we'll hear from Jennifer Prusak, Associate Clinical Professor of Law and Director of the Housing Law Clinic in the Vanderbilt University Law School. She'll provide some possible solutions via her work on providing low-income renters with legal counsel, as discussed in her paper, Expanding the Right to Counsel in Eviction Cases: Arguments for and Limitations of Civil Gideon Laws in a Post-COVID-19 World. And we're going to drop links to those papers in the chat during the webinar, so you'll be able to access them. This webinar is supported in part by funding from the U.S. Department of Health and Human Services, Office of the Assistant Secretary for Planning and Evaluation. But views expressed by our speakers don't necessarily represent the opinions or policies of that office or of any other sponsor, including the University of Wisconsin-Madison. We have an hour today, and after we hear from each of our presenters, we'll spend the last 15 minutes or so at the end for a live Q&A. You can type those in through the Q&A box. We also did get quite a few questions submitted as people registered, so we'll also be queuing some of those up as well. I hope you'll also feel free to participate through the chat. We'd love to know who's joining us. And I want to let you know that we do have closed captions enabled, so you can toggle those on and off at the bottom of your screen. We'll be posting the slides and the recording of the webinar within a day or so, and you'll receive a link to those by mail. So with that, thanks again for being here, and we'll get started with Professor Lentz.
Thank you so much, Judith. And it's really incredible to see such a substantial crowd on this Wednesday morning on the West Coast. I imagine it's afternoon over in the Midwest. So I think of eviction as holding a kind of an odd place within the justice system. It's hard to find a perfect estimate, but the most recent research out of the Princeton Eviction Lab suggests that up to 7% of U.S. renter households have an eviction petition filed on them every year. 1 in 4 children born into deep poverty will be evicted within the first 15 years of their lives. On top of that, many others are threatened with eviction or perhaps informally evicted by their landlords in ways that we can't really collect reliable data on. So I say that eviction holds an odd place because, we have such a high prevalence of eviction, and rarely are the stakes so high for people in a civil proceeding. So losing a home causes and exacerbates so many challenges for people who are evicted, and this happens to those who can least afford to face such challenges. Housing is the greatest cost in most people's lives. It's usually not close. And then these eviction events, of course, occur to people who are often without resources to deal with either the proceedings of eviction or, of course, the aftermath. And because eviction is a civil proceeding, defendants do not have a right to counsel in any but a small number of jurisdictions where those types of resources have been provided. The formal eviction process varies substantially across the country, based on various, tenant protections and, landlord-friendly policies. But typically, the eviction process is going to begin for a tenant when the landlord provides the tenant notice that they have or will file what is called an unlawful detainer petition against the tenant. That's the formal language. That means somebody is detaining or occupying the property unlawfully, but either verbally or in writing, and in most places it's supposed to be in writing, a landlord is likely to tell them or have an agent tell them that they're being evicted or taking them to court to evict them. When the landlord files a petition, at least in California, the landlord must then serve the tenant a summons and a complaint, after which the tenant has 5 days to file a response to the court. Then comes court dates, a potential trial with or without legal counsel. And an important thing to note is that in the vast majority of cases, tenants do not show up to court and lose the judgment by default. Landlords are far, far more likely to have legal representation than tenants in this process as well. There are a few things I want to note regarding what my co-author Kyle Nelson and I have discussed as the institutional life of eviction. One is that eviction is both deeply profound as an outcome, but also troublingly mundane in the context of many tenants who experience housing trouble of some sort, quite regularly. For most of us who have been stably housed, for decades or our entire lives, we cannot really imagine how disruptive a notice of a potential eviction might be. But if you've been fighting with your landlord about various unaddressed maintenance issues and your family is constantly teetering on the brink in terms of affording food or healthcare or shelter or transportation, like you can see how heading to eviction court can get lost in the shuffle of many problems, or these folks may simply choose to leave a bad situation. And this is exacerbated by what Kyle Nelson calls interpretive disjuncture, or better stated, in non-sociology the disconnect between the way lay people and experts interpret and treat everyday troubles as legal problems. So again, some folks don't really kind of understand an eviction notice as being as profound as it really is going to be in their lives. More broadly on a normative level, this country has not really grappled with the system it wants to have when it comes to eviction, in my view. We're muddling through a system with poor support and a default, but not total fealty to property rights. But landlords hate eviction too. Tenants hate eviction. Lawyers don't like it the way it goes. Advocates don't like eviction. Nobody is satisfied. It depends on the jurisdiction as to how tenant or landlord friendly the process is, but the right balance is usually quite elusive. And I say this because this is really a policy area that needs more clear normative goals before we can figure out what the right policy solutions are. And for those who might think, well, public housing or massive housing subsidies are clearly the solution, it's important to note that housing subsidies don't remove the threat of eviction. People are not only evicted by private landlords when they're using housing vouchers, but housing authorities evict people from public housing all the time. Some jurisdictions even evict from public housing at a higher rate than private landlords, although it's really hard, of course, to control for the poverty of the population in those studies. I'll conclude by noting that there are some unintended consequences from some seemingly tenant-friendly policies. I'm here in Los Angeles, where the county court system is unfathomably large geographically and also in terms of population. And for that reason, we used to have 26 small claims courts around the county, most of which handled eviction petitions. We then went to a hub model where only 6 hubs handled such cases. So you can imagine then the geography that people had to travel to get to these hubs was far greater after that change. But after they closed a handful of those locations, they found that tenants were more likely to be represented by counsel because the low cost and nonprofit legal centers were better able to cover a small number of courts. So on the one hand, dismantling this neighborhood-based court system made it more difficult for tenants to physically access these regionally dispersed courthouses. But on the other, having this hub system expanded tenants' access to legal justice in an unanticipated way. So you could go in either direction, but there is, at least in a county as large as LA's, a trade-off between this kind of, access to the courts spatially and the access to legal counsel. So I hope this introductory context was useful, and now I believe I'll hand it to my friend Eva Rosen from Georgetown.
Thanks so much, Mike, for that introduction. That was a super helpful lead into what I'm going to talk about now. And before I start, I just want to thank my collaborators, Isaiah Fleming Klink and Brian McCabe, for their work on this project as well. And what I want to talk about today is eviction, specifically from the perspective of what actually happens in the courtroom. As Mike alluded to, there's a big part of the eviction process that happens outside of the courtroom as far as legal filings and interactions between landlords and tenants. But this research is specifically about the courtroom, and it's specifically about one courtroom, which is eviction court in Washington, D.C., which is mostly in one room, although there are a couple of rooms that do handle cases. And it's related to a set of observations that we did in 2018. So I do want to highlight that this was before the pandemic, and there are some things that have changed. And as I'm talking today, there will be some things about this particular courtroom that will be probably common in other courtrooms across the country, and other things that probably work pretty differently. So we can maybe use this as a sort of a case study to think about some of the kinds of things that might come up that we might want to be aware of when we think about what's happening in the courtroom, but also be aware that this isn't necessarily generalizable everywhere. Next slide. So as a background, I just want to say that renters summoned to court for an eviction navigate a really complex set of administrative processes as their case winds through the court system. And Mike alluded to this. And there's been not a lot of scholarship on the institution of the courtroom itself. So in this paper, we look at the courtroom where eviction filings are handled to really think about both how the formal processes as well as informal processes, which together we call hidden procedure, unfold within the courtroom, really shaping experiences both of landlords and of tenants in court. And what we argue with this work is that there are a set of formal and informal rules, norms, practices that end up guiding this legal process. And that ultimately in the space that we observed, this created a set of mostly disadvantages for tenants and mostly advantages for landlords. Next slide. So really quickly, just to tell you about the data, we observed landlord-tenant court, which is what eviction court is called in DC, for about 400 hours over the course of a year in 2018. We also did around 200 very informal interviews, because this was really an observation study, interviews and conversations with actors throughout the system, including tenants, but also various court actors and landlords. And this is complemented by a database of administrative records that includes all of the evictions that were filed in Washington, D.C. between the years of 2014 and 2018. And we've got information there on legal representation, on all the different events in the life of a case, as well as on case outcomes. Next slide. So on the tenant side, as I mentioned, we find that tenants are quite systematically disadvantaged in this courtroom. And this is really undergirded by two key contextual factors. And again, these are the kinds of things that you might want to ask yourself. Is this true in the eviction courtroom that I'm most familiar with? And the first is that the eviction courtroom in DC is very overburdened. And this is, of course, common. There are a lot of cases, and there's very little time to spend on each case. And the second contextual factor is that the vast majority of tenants, again, this is true in most places, around 98% of tenants come into the courtroom without legal counsel. And that as I talk about the subsequent challenges that tenants face, you'll see how they're all sort of exacerbated by the fact that tenants don't have legal counsel. So this disadvantaging really begins the minute the tenant walks in the door. There aren't a lot of signs or directions when people walk into the courtroom about where to go or what to do. It's unclear where to sit, what will happen once the hearings begin. It can be very noisy in the courtroom. Tenants are frequently unable to hear their own names called. And if they don't hear their names called and they don't say present or here, there may actually be a default judgment against them, which could lead to a faster eviction. So again, here with each of these problems, you can sort of see how without someone there to represent them and to guide them through that system, it's confusing. It can be quite unfair. In addition, related to this high volume of cases that I talked about, we observe judges and other court staff frequently urge tenants and landlords to go out into the hallway and try to discuss and even settle their cases outside the courtroom, whether that's through an informal agreement between the two parties or through a more formal settlement agreement that might later be sanctioned by the court. And these are what scholars have often called shadow processes, right? These are happening outside of the courtroom, outside of the judge's oversight until it maybe comes back into the courtroom. And it can result in really unbalanced negotiations where tenants don't always fully understand their rights and responsibilities. And this can lead to unfavorable outcomes for them. And from our administrative analyses, we saw that a quite substantial portion of these cases did result in some type of settlement agreement, and that's something for us to pay attention to. And again, this gets exacerbated by the fact that there's such a high volume of cases that judges are trying to deal with. Their hands are a little bit tied, right? They're trying to come up with solutions, and this is one of the ways they can do it. And then finally, I want to point out that there are really significant opportunity costs for tenants to appear in court. They have to probably miss work, maybe find childcare. If they don't appear in person, their case will move to a default judgment, as Mike pointed out, and often to a swifter eviction. And so the stakes are very high for them. And they could lose their home if they don't show up, and yet the costs are quite high. Next slide. So I want to draw a contrast here in that our observations in the courtroom made very clear the ways in which, in contrast to tenants, landlords actually have some systematic advantages. And these advantages are primarily conferred through their attorneys, who often go to court in their stead and who form connections with other court actors because of this regular appearance that they're making in landlord-tenant court. So just as a really quick anecdote, there was a morning in which we observed a landlord attorney who was waved through a long security line, stretching out the door to get through the metal detectors, and the security guard sort of saw the attorney waiting in line and said in a very friendly tone, "How was the weekend?" and then just sort of let the attorney skip through the line. Now, this is not something happening in the courtroom, but you can immediately see through this type of interaction that landlords are well known to court staff and may benefit in all kinds of different ways. And I think there may be a link going around with the paper that this research is based off of, and you can read about all the ways in which that actually played out in the courtroom as well. So what this means is that landlord attorneys don't just know the courtroom staff, but they know these sort of unwritten rules. They also know which clerks are responsible for different kinds of filings or where to go with questions they may have. They, of course, are trained in the language of court, and they know how to utilize the procedures of the court for the benefit of their clients. None of this is wrong or bad. This is all good, but it is not what tenants have and not what tenants experience, and so it does create this power imbalance. Reciprocally, court staff also know the attorneys, and so when they don't show up, or maybe they're tied up in the hallway, they know how to go out and find the attorneys and let them know that their case is about to be heard. And that can be tremendously beneficial. So through this familiarity, or what sociologists call social capital, landlords, through their lawyers, benefit in all kinds of ways that tenants do not. We also see this phenomenon show up in the administrative data, where we see that the same landlord attorneys are appearing in court day after day for different landlords. So our analysis shows that lawyers from just 3 legal firms represented a full 62% of cases in court, which is a really powerful statistic to help understand how you have sort of the same people coming in again and again on the landlord side. Also, those from 15 firms represented landlords in a full 95% of cases. And this is true even when we look at the landlords themselves. There were just 10 landlords in the city who were responsible for over 40% of the filings. So it really shows how concentrated these filings are among a small number of actors. And more importantly, for what we're talking about here, how concentrated this social capital is among a very, very small number of actors who are actually coming to court every day and getting to know judges and clerks and security guards and court procedures and systems. Finally, we also see this familiarity play out in the form of what we call judicial nudges, where judges may routinely aid landlord attorneys with their cases, especially when the judge knows the attorney, and that can play out in all kinds of small ways. I'll let you go to the paper for the examples for the sake of time so that we've got enough time for Q&A here. Next slide. So in this work, we show how the hidden procedures in the courtroom explain how power asymmetries are created from the moment landlords and tenants set foot in the courtroom. And so whether it's the physical layout of the courtroom to the inconsistent application of formal rules, we show that tenants are often lacking the tools to navigate this bureaucracy, while on the other hand, landlords through their attorneys are quite adept at doing so. And these burdens are exacerbated by limited access to legal representation and by the high opportunity cost of appearing in court. On the flip side, we show how landlords are really benefiting from familiarity and social capital with courtroom actors and procedures to garner these advantages. Now, our findings generate suggestions for policy that both limits eviction filings before they happen to keep tenants out of courtroom in the first place, as well as policies that might ease the burden of the eviction process within the courtroom. So I'll just show you one last slide, if you can advance, thank you, on policy to sort of think through these three different levels at which we might target policy. And these are going to vary in different places, and they're going to have all kinds of different specificities depending on what state this is going on in, but I think there are some common lessons here. And the first is that we might seek to avoid eviction altogether by thinking about a more root cause of eviction, which is affordability. So we think that policymakers should work to keep tenants out of eviction court altogether, right? Reducing the number of eviction filings has to begin with policies that generate sustainable, affordable housing for families who are at the highest risk of eviction. And we can think about any number of different kinds of projects in DC. We have something called the Housing Production Trust Fund. We have the local rent supplement program, but nationally, of course, there are other policies like housing vouchers or public housing or different kinds of zoning regulations that we might think about to make housing more affordable. At the second level, we might think about preventing evictions once they have been filed for. So again, in DC, there's a program called the Emergency Rental Assistance Program. There are similar programs all across the country, many of which were funded by COVID funds. So I'm trying to make programs like this that provide tenants with funds to pay any rent that they owe before they're evicted can intervene in this interim stage where the eviction has been filed, but it hasn't yet been executed. We can also use these funds to try to keep cases from being filed at all, right? So if cities and states provide these funds to tenants before the eviction is filed, we can actually keep their name out of the eviction system to begin with. And we could also take existing programs. For example, we have something in DC called the Attorney Resource Center, which does provide attorneys to a small number of tenants before they come in. And expanding programs like that into more universal type legal counsel legal assistance could really help to even the playing field between these two parties and to make these kinds of resources available to tenants before they actually appear in court so that they can fight this case as best they can. And then finally, we do need to think about making the court processes function more fairly once tenants and landlords are actually in the courtroom itself. And I should say that interestingly, there have been a number of changes in DC that have been implemented since the COVID-19 pandemic. In particular, a lot of these proceedings have moved online. And so some of the difficulties that I mentioned around hearing the name being called and showing up and traveling to the courtroom might be really lessened by the fact of having a proceeding online. Of course, not everyone has access to internet and a computer, and so there are problems there. And this study, was not conducted during or after the COVID-19 pandemic, so I can't entirely speak to this, but it's interesting to think about the ways in which we might use technology to solve some of these problems. And finally, I'll just end on this point of a right to counsel for tenants. Could be another step that would be taken to really make the court processes function more fairly. If both sides have representation, they have advocates to make sure that their rights and responsibilities are clear to them. And it sounds like that's what we're going to be talking about in the next talk. So I will turn things over. Thank you so much.
Thank you, Eva. So that's a great segue and a great introduction, because I am going to be spending a fair amount of my time talking about right to cancel programs generally as potential solutions to the eviction crisis and what limitations these programs have in achieving those goals. Some of what I had wanted to talk about was already covered by Mike and Eva, so I'm going to be going a little bit shorter than I had initially planned for the sake of brevity, and so that there's not too much repetition here, and also so that we have time for questions at the end. So my name's Jennifer Prusak. I am the director of the Housing Law Clinic at Vanderbilt Law School in Nashville, Tennessee. And the goals of the Housing Law Clinic are twofold. First, we provide second and third year Vanderbilt Law students the opportunity to gain experience practicing law by allowing them to provide direct representation under my supervision to low-income renters facing a host of housing challenges, including housing insecurity, unsafe housing, and discrimination. Because renters, low-income renters, even if they're not at risk of eviction, often have a whole host of housing-related problems that, we're actually not, it could be subjects of many other webinars we're not going to be talking about today. So that's our first goal. The second goal we have is the Housing Law Clinic works to fight housing insecurity generally in Tennessee through direct advocacy, legislative efforts, and community outreach and education. We accomplish these goals both by leveraging Vanderbilt Law School's resources and commitment to public interest lawyering, and by partnering with state and local agencies that are themselves committed to helping people facing housing insecurity remain stably housed. So a lot of what my students and I do in our clinic is provide direct representation to very low-income renters facing eviction in general sessions court, what is known as small claims court in many other jurisdictions. Everything that my prior two panelists have spoken about during their presentations, completely borne out by what my students and I see every week in court. And so I'm not going to repeat most of what they said here, other than to highlight a few key points. First, race is unquestionably a factor in who faces eviction and who does not. The people who find themselves in eviction court most frequently, they're statistically much more likely to be BIPOC individuals and families than white people. Black women face eviction at far greater rates than anyone else. And as both of my prior panelists said, there is tremendous access to justice imbalance in eviction cases. Renters facing eviction are far less likely to be represented by counsel than landlords. All you need to do to see this is observe court during an eviction docket. The rates of representation that people facing eviction have is going to vary a lot from jurisdiction to jurisdiction. But the one thing that all jurisdictions have in common is that, generally speaking, landlords tend to have legal representation, renters do not. And this access to justice imbalance is due to a host of factors. For one thing, renters facing eviction rarely have resources to pay for legal assistance. And sources of free legal help are limited and stretched thinner than I think the general public realizes. Legal aid organizations and law school clinics like the Vanderbilt Housing Law Clinic have historically been the chief sources of pro bono legal representation for low-income renters. But neither legal aid organizations, who are constantly facing budget cuts, nor law school clinics that are generally staffed by law students and a supervising attorney, they just don't have the capacity to meet the total capacity of need. And the ways in which this differential in access to justice impacts renters facing eviction cannot be overstated. And I'll just go into this briefly since it's already been covered. No access to a lawyer means you will not know your legal rights as well as a party with counsel will. You won't necessarily know how to comport yourself in court. You won't know which facts are relevant and which are not. And you won't necessarily know which arguments are the best arguments to make to preserve your housing. And it is this point that the fact that parties represented by council fare better in eviction court than people without representation that has inspired the current right to counsel movement among housing advocates, and has, in my opinion, this has become one of the most frequently discussed and most frequently sort of pro-offered potential solutions whenever people discuss solutions to the eviction crisis. One small point of clarification. So right to counsel is something that eviction and that housing right advocates talk about a lot. But it's important to remember there's no actual civil right to counsel guaranteed in the Constitution. Calling increasing access to counsel for low-income renters a right to counsel program is a misnomer. Just so we're clear on this, the only constitutionally guaranteed right to counsel is in state criminal proceedings. And so generally speaking, when housing advocates talk about a right to counsel program in the eviction context, they most frequently mean an increase in attorneys made available to work with people facing eviction. The idea behind these programs is quite simple. If renters in eviction court face worse outcomes generally when they're unrepresented, increasing access to attorneys should help keep them housed. And it's an idea that is supported by data. New York City was the first city to implement an eviction right to counsel program nearly 10 years ago. They started at that time guaranteeing an attorney to all residents of certain zip codes whose incomes fell below a certain threshold. And when they did this, rates of eviction dropped. They didn't fall to zero, of course. If a renter has no defense to an eviction, having an attorney will not necessarily be a magic fix-all. But I'm not going to go into all the statistics now, but there's extensive data that shows that yes, renters with an attorney have a better chance in court of staying housed. And even in situations where an eviction is not defeated per se, the presence of an attorney lets renters have more meaningful negotiation discussions outside of the courtroom, the sorts of shadow proceedings that happen that Eva was talking about. If renters have an attorney with them, those proceedings go a lot better. And even if they are not ultimately able to stay in their rented space indefinitely, they may get more time before they have to move out. They may get more equitable repayment agreements and so on. New York City's program was successful enough at preserving renters' housing that other jurisdictions began to follow suit and create right to counsel programs of their own in other cities in the country. And when the pandemic happened a few years ago, there was a national spotlight on our country's eviction crisis for the first time in years. There suddenly were federal and state funds available to create programs to help low-income people remain housed. There was, of course, a federal eviction moratorium as well that stopped all evictions for a while. That was very effective in stopping eviction, but it was, it only lasted for a short while. And of course, there was also a lot of state and federal assistance dollars that went directly to emergency rental assistance programs that allow people to pay back rent and so on. But towards the end of the pandemic, when support for eviction moratoriums and rental repayment programs waned, a number of jurisdictions started funding programs like the one piloted in New York City, calling them right to counsel programs, with the goal of leveling the playing field in the courtrooms so that more renters might be able to stay housed. And today, there are dozens of eviction right to counsel programs around the country, including Nashville. I believe we're in our third year of having one. And, you look at the eviction rates in cities that have, in states that have these programs, and it's undeniable that renters are benefiting from this and being able to stay more stably housed. But it's important when talking about increased access to attorneys in these programs that we acknowledge the very real limitations of right to counsel programs in the eviction context. They're not a one-stop shop. They are absolutely not a magic bullet to solving the eviction crisis. because, when you look at the sheer number of people facing eviction in the United States, it is impossible to imagine a scenario in which there are enough attorneys, enough trained attorneys, to truly give legal representation to every low-income person facing the loss of the housing. And the success of these programs is determined largely by the amount of funding, the number of trained lawyers dedicated to it. And of course, none of this addresses any of the underlying causes of eviction in the first place. The lack of adequate, safe, and affordable housing in this country for everyone who needs it, and the failure of wage growth to keep pace with the skyrocketing increase of housing prices in many regions of the country. Unless those things change, we're still going to be facing thousands of people every year in the US at risk of losing their housing. But it's easier. I mean, it's not easy, but it is simpler to fix a problem by hiring more attorneys and giving renters more access to legal representation in court than it is to fix the underlying deeply entrenched and systemic societal factors that lead to eviction in the first place. And so, given everything else, given the serious limitations that certain cities, certain states really face, the shortfall of affordable housing, the fact that these right to counsel programs exist is truly a great thing, a huge step in the right direction. But I do think that it's important, to always acknowledge, that there's only so much that more attorneys can do. And so there are many other solutions that are discussed in the eviction context. In the interest of time, I'm simply going to refer you back to the possible solutions that Eva discussed in her presentation. Much of what she talked about were things that I was going to talk about in my presentation. In the interest of time, to make sure there's time for questioning, I'm just going to refer back to that wonderful slide she had at the end of the presentation and say, yes, these are things we need to be doing as well. Increase funding and emergency rental assistance funds, building more affordable housing, lobbying for zoning changes, all of that absolutely needs to happen. The only other solution that I would like to flag is that partnerships between legal aid organizations and housing law clinics and the nonprofits who work with at-risk of housing insecurity populations can be a wonderful way for housing rights advocates and for legal aid organizations to flag problems with families, with a person's housing situation before they really spiral and snowball out of control to the point where eviction is inevitable. If housing rights advocates, if people working with low-income renters, if attorneys can sort of get in there and identify the problems and do what they can to fix them, begin negotiations with attorneys, that is a really invaluable way to keep people housed. It's also very highly labor intensive and highly resource intensive. You need a lot of people on the ground with good communication with the renters and with the landlords. But, in general, I think that all of the solutions that we've been discussing today, there really isn't one thing that, let's change this and everything will be better. It needs to be a multi-pronged, multifaceted sort of approach to all of it in order to keep our most vulnerable people housed. And that's essentially all I have. So I think, Judith, if we want to turn it over to questions.
Yes. Thank you so much to all three of you, Jennifer, Eva, and Mike. Great perspectives, and your information sharing really complemented what the others were saying. We do have some questions already queued up, but also please feel free to drop them into the Q&A box, and we will get to as many as we can. I want to go kind of all the way back to the beginning. Mike, you were saying that for people who have been stably housed, it can be hard to really appreciate the process and understand what people are going through. I think one really basic question that I have is how long in general, and I'm sure there's a lot of variation, but how long is the process generally from when a landlord maybe decides to evict a tenant and to that court hearing and then an eventual eviction if it happens. Mike, do you want to start?
Yeah, I mean, you're right, first and foremost, Judith, that it just varies a lot across by jurisdiction. So, you know, and I think one thing to remember maybe is that, and I think somebody like Jennifer, who's, more steeped in the legal aspects of eviction, could maybe provide some color on this, but like, our country varies a lot in terms of its tenant friendliness, landlord friendliness, and so I'm in California, which has a pretty good reputation for being on the tenant friendly side of the spectrum. Jennifer agrees fully. And I know I know some scholars who study eviction in Georgia, at where things are extremely different in terms of down, says Jennifer. Okay. Thank you. I should have Jennifer just like stand next to me in class and emote. This is great. And so so that's a small piece, this kind of time to eviction or time to trial or whatever, the various steps between, getting a summons versus getting to a trial or a first court date or whatever. That's a small piece of, but an indicator of how things might vary across the country, right? In terms of this tenant friendliness versus landlord friendliness. I mean, I think in California, I think what I said in Los Angeles in particular is that, the tenant has something like 5 business days to respond to a summons. But that's like responding in writing to the court. Then there's some processing time that's going to occur after that. So it's minimum going to be like a month or so in California where before you're going to be expected to come to court after receiving a summons. But that's going to vary a lot across the country.
So part of the reason I wanted to ask that is I just recently did a podcast interview with Carl Gershenson, who's the lab director at the Eviction Lab at Princeton. And he said that one of the promising policy approaches is building more time in for the tenants in that process to remedy what they are being evicted for. And I guess, Jennifer, maybe I'll turn to you. Is that something with the folks that you and your students are representing? Do you see points in that process where you think, oh, if the landlord had been required to provide the tenant with, say, 2 extra weeks instead of 5 days, that could have been a turning point for that family?
Absolutely. Absolutely. I mean, so much when renters receive notice of eviction, the amount of shock and fear that a lot of them receive cannot be overstated. And, when you get something that's that potentially disruptive and terrifying, a lot of people really they freeze. And so the first couple of days, they're really just trying to sort of figure out what their rights are, what their options are, and so on. 2 weeks can give them the time they need to find a new place to live. 2 weeks can give them the time they need to get money together to sort of cure the default and so on. Yeah, so a lot of what we do, we're in Tennessee, which is part of why I'm right next to Georgia, and it's part of what inspired my thing. I've represented renters in San Francisco and in Indiana and Tennessee, and our renters do not have many, relative to what they are in other parts of the country. They don't have a lot of rights here. And, we try hard to get them as much time as possible, because more time gives them more options. Yeah.
Eva?
Thanks. I wanted to weigh in on this question of time as well. And I think some of our administrative data from DC can help us to think about this question as well. And what we see is that in the District of Columbia, relative to a number of other kinds of places, things do take a little bit longer to work their way through the process. And most importantly, we have something called right to redemption in DC, which exists in many places, but not all. And it basically means that the tenant can pay any rent that is owed up until the moment in which someone comes knocking on their door to say you're being evicted and we're changing the locks and it's time to leave. And that's important because what we see in DC is that of the around 32,000 filings that happen per year, only about 5% of those filings actually result in an eviction. And what that tells me is that a very large percentage of tenants are actually paying their rent during this period of time in which the case is unfolding. There are other things that could be happening. The case could be dismissed for some reason. The tenant might decide to leave on their own without paying. That is all possible. But ultimately, that statistic of only about 5% being making its way all the way through to an eviction is an important statistic. Because it really highlights some of what Jennifer was saying around that time being important for tenants to try to come up with that money, especially in places that have resources like emergency rental assistance programs that tenants can tap into, but it might take a second for them to actually come up with that money. And this is relevant to one of the questions in the chat. Yes, unfortunately, there are cases where prolonging that process might mean that the tenant then owes more at the end. But these are empirical questions we can actually go in and answer. And what we see is that most of the time, the tenants are coming up with that money and paying that money. And that gives us a little bit of data to support this approach of prolonging the process and allowing a little bit more time for people to gather the resources that they can to prevent the worst outcome, which is losing their homes.
Thank you all for those insights. And Eva, I'd like to stay with you for a moment. You had those statistics about the relatively small number of legal firms who are representing so many of these landlords. And I want to turn that around a little and ask about the landlords. What do we know about who is filing eviction notices against their tenants? When you look at smaller landlords who may only own a few units versus huge corporate landlords who, own hundreds, if not thousands of units.
Sure, and this is an area where I want to be tentative because we need a lot more research. But what we found in DC is that when we look at the larger, more corporate landlords, they tend to file on their tenants more frequently. They often have a schedule on the first day of the month that they're allowed to file. They'll go ahead and file like clockwork. And I have other papers that look specifically about landlord attitudes around that and how they think about what that means to them. So they tend to file more quickly and more frequently on their tenants, but those eviction suits tend to result in an executed eviction less frequently. And that's important. It's directly related to what we were just talking about. In other words, they're sort of using that filing process to get things on the book, to push the tenant to find a way to pay, to put a little bit of legal weight behind their request for rent collection. In some cases, it's the thing that actually allows the tenant to go and ask for emergency rental assistance. They may need that suit to actually get the assistance. That's something we can change. That's not necessary. That's something we changed in DC. Tenants should be able to tap into emergency rental assistance without having to be filed against and having their name go into a database. In contrast, when we look at smaller, more sort of amateur mom and pop type landlords, we see that they tend to file on their tenants with less frequency, but when they do file, it's more likely to result in an eviction. So you see very different approaches there being used by different types of landlords. And again, this is something that needs to be looked at, on a much larger scale. But I think it is important to think about the way, certainly in DC, what we argue is that the legal system, the eviction court system, becomes a place where landlords are essentially collecting rent. And it overburdens the legal system. It means that the judges and the eviction courts have less time to really sit down with some of the more complicated cases where there may be issues around housing quality that really need to be adjudicated. And so there's a lot less time for those kinds of cases because they're dealing with very straightforward cases of non-payment of rent that might have been settled in other ways, or maybe if the landlord had just waited a couple of weeks, that rent would have gotten paid. So you see that the same tenants are actually being filed on for filing late every single month. And it really points to this need again for more resources, for more attention paid to affordability, to sort of keep things out of the court system where we can and save the court for some of the more complicated cases.
In both our webinar chat today and in questions that were submitted as people were registering, there's a theme of people wanting to get really creative about ways to support people, households, like you said, Eva, sometimes people facing this month after month after month, and the ongoing stress and burden that is. One of the questions that was submitted is, what's the best suggestion you all can give to nonprofit organizations working directly with the population being affected by eviction? And I'm reading into that people who may be coming for a different type of service or support, but are also dealing with housing. And then we also had a question, any thoughts or data on non-lawyer advocates providing representation in eviction court? More and more states are exploring or experimenting with licensing limited legal professionals. And so there's just this theme of what can the rest of us do to help? Jennifer, do you want to start us off?
Yeah, so my clinic has a close working relationship with several nonprofits here in Nashville that their missions are not necessarily to prevent evictions or to help people with their housing questions, but their mission is to do other things. Like one of them works with victims of domestic violence to sort of move on with their lives. It's sort of one example. But these partnerships that we have with these nonprofits, even though their goals are not directly to help preserve housing, a lot of the individuals that they service have housing issues. They tend to be low income individuals and families. And so what my clinic has done is we've actually provided trainings to the staff of several of the nonprofits here, so that we're not really giving them tools to give legal advice per se, but we're sort of educating them on the kinds of things renters can do to make sure that their landlords view them as good renters, and to help them minimize the chances that they might find themselves facing eviction. And so in that way, we're sort of leveraging committed, non-lawyers, their interest in helping this population, giving them the tools that they need to sort of counsel people to become sort of better renters, and things to look out for when landlords might be about ready to file. So that is sort of one thing. I think that working with non-lawyers who are committed to helping this population is an outstanding idea. I think it's an underexplored idea. I think that, the more people we can get involved to help people before the eviction is filed, the better. And I feel like if a nonprofit has a close working relationship with people at risk of housing insecurity, that's just one excellent way to do that. With respect to the question on, can we allow non-licensed people who are not licensed attorneys to do eviction defense in courts? I don't know that I'm necessarily against that. I think that whether or not that's feasible is going to come down a lot to like which state you're in. I don't know how feasible that is. I do know that there's a lot that non-lawyers can do in this sphere. Even leaving aside whether or not they can make arguments in eviction court, there's a lot of forms that need filling out. A renter who needs to file an answer to something they've received in the mail, they may not even know where in the court to go to find the forms that they need. Non-lawyers can absolutely be trained to direct renters the right place to go on the internet to find the forms that they need to. I just feel like there's a lot of room for people without law degrees to get involved. I don't know if that addresses your question at all. But
that was great. Mike or Eva, anything to add?
I didn't have anything to add on that side of it. I did want to kind of echo some nuance that Eva was talking through about kind of differences between smaller or mom and pop landlords and maybe corporate or larger landlords. Some work that we did surveying tenants in Los Angeles during the pandemic found that folks that were either, especially folks that were like an arm's length, like family or friends, and also smaller landlords were more likely to threaten evictions during eviction moratoria than larger corporate landlords. And so, you know, to me, it kind of brings a little bit of complexity to this idea that like these large corporations are like the worst types of offenders in landlord tenant relationships. I think what it specifically says is that those types of landlords are more equipped to follow the law as it is being laid out and possibly evolving in particular communities. So I just wanted to kind of throw out that data point as something that is, I think, supports a little bit of the nuance that Eva was talking about.
Great, thank you for that. One theme, again, that has emerged in the questions that were submitted and what I'm seeing in the chat is people really wanting to advocate for change that can make this process maybe not easier, but avoid the process when possible and make sure that people are supported as they go through it. And I guess the question I have is, from the experience and research that all of you have done, is there a level at which advocating for particular policies or practices is most effective? Is it at the local level? Is it at the state level? Or are there federal fixes that could, kind of leapfrog over that patchwork of depending on where you live and how you're going to be treated as a renter? And anyone who wants to start can start.
It strikes me that, the funding is often best found at the federal level, but not always. Specific localities maybe have the most control over how courts operate and behave, so that's more local. But state level is kind of maybe in a sweet spot in both areas, both on the funding side and the regulatory side, because we do typically have state court systems that do at least try to provide a administrative framework for how local jurisdictions operate. And they are also better equipped to raise money for defense in a lot of cases than very small jurisdictions. But that's my kind of basic framework there.
Okay. Jennifer, Eva?
So the state of Tennessee is complicated, in that we have a state government that is not overly concerned with any of what we're talking about today, and they're very, very pro-development, pro-landlord. I see someone said what she said. That must be somebody else from Tennessee. And there's a lot of effort at the Nashville level to get things done. But then if Nashville does something, the state government will preempt it. And so like nothing ever really happens. So I think in Tennessee, several of my colleagues at Vanderbilt engage in a fair amount of lobbying projects with the state government, but it's, and I'm not going to put words in their mouths, but I do think to some extent it's more a way to expose law students to the legislative process and to teach them how to cope with trying real hard and not getting anywhere than it is because they actually think something. So I would say that in this state in particular, even though housing is often a very state, very local thing, if you want things to really, really happen, I would argue focusing federal might be more beneficial. But I think that is an answer that's very specific to where my clinic is located and not one that I would necessarily say applies everywhere.
Right. And Eva, we'll give you the last word.
Sure, I'll try to be brief. I would just say, and this probably comes also from where I'm located, which is DC, which is sort of an odd political jurisdiction, of course, and maybe gives us some insight. I think that both because of political considerations across the country, the kind that Jennifer was referring to, as well as the fact that there are so many different levels at which we can make reforms that help this situation. I would say there are things to do at every level. And I don't disagree with anything Michael or Jennifer said as far as the power of the federal level, but I do think there's a lot that can happen at the local level when things aren't moving at other levels. And so it depends on whether we're thinking about addressing root causes of affordability or more sort of downstream types of interventions in the courtroom itself. But there's a lot that can be done at all levels. And so trying to think about what could you do where you are that's useful, or what can you fight for that might help to make a change. Even if you can't do things at the other levels, might be a productive way to think about it.
Great. Well, thank you all for a great conversation. Mike Lentz, Eva Rosen, Jennifer Prusak, thank you for sharing your time, experience, and research with us today. Clearly a lot of interest and a lot of passion about this topic, and I know I learned a lot, so thank you all. Thanks also to Natea Taylor and Dawn Duran for handling tech for the webinar. As we mentioned before, we'll be posting the slides and recording of the webinar within a day or two, and you'll receive a link to those by email. Thank you all for joining us, and have a great rest of your day. Take care.